The power of the seal: how to authenticate, protect, and monetize your judgment instrument. 1. The seal is signature of office. A signature says, "I agree." A seal says, "I decree." In private law, the seal is not decoration, it is jurisdiction embossed in wax, ink, or impression. The moment a seal is affixed, the paper becomes evidence of a living act. So what does that actually mean? It means ink shows intent, but a seal proves authority. The executor's seal replaces the judge's bench stamp. It certifies that the document originates from a living source of law, not a corporate fiction. Each sealed instrument stands as a notarized act of your private court, self-authenticating under commercial rule. Footnote: the executor's seal serves as judicial authentication, converting private documents into recognized acts of lawful authority. 2. Constructing the seal: substance over symbol. Forget fancy designs. The seal's power comes from its lawful purpose, not its ornament. It may be embossed, inked, or impressed with wax, but it must carry the executor's name, title, and the phrase in private capacity. So what does that actually mean? It means you can trade the gold foil for clarity. Your seal becomes valid through intent and consistent use, not artistic merit. Every instrument it touches carries your standing, your oath, and your liability. Consistency makes it binding, caprice makes it void. Footnote: a seal's authority arises from lawful intent and uniform application, not aesthetics. Consistency proves authenticity. 3. Securing the judgment: the seal is bond. When a judgment is sealed, it becomes a bonded instrument, a financial asset recognized under both equity and commercial law. Why? Because every unrebutted affidavit of claim is, by definition, a verified account. When sealed, it becomes negotiable through lawful assignment or trust deposit. So what does that actually mean? It means the pen that wrote it just printed value. The executor may lawfully assign the judgment to a trust, treasury, or private fund for safekeeping or offset. This does not sell the judgment, it collateralizes it, turning truth into credit while keeping ownership intact. Footnote: sealed judgments form bonded instruments capable of assignment, collateralization, and lawful deposit under equity and commerce. 4. Protecting the seal: guarding against misuse. Never share or digitize your master seal. Its value lies in its uniqueness. Duplicate seals without authority can create counterfeit jurisdiction, the legal equivalent of identity theft. So what does that actually mean? It means your seal is your soul, guard it like one. Keep a master ledger of every sealed document: date, subject, recipient, and purpose. This establishes a verifiable chain of custody, ensuring no fraud can occur under your name. Footnote: maintaining a seal ledger preserves authenticity and provides proof of jurisdictional custody over all issued instruments. 5. The living bond: when seal and record become one. Once the judgment is sealed and registered, it becomes a living bond, a self-backed promise supported by law, fact, and faith. It no longer needs advocacy. It needs only stewardship. So what does that actually mean? It means the moment you seal your record, it starts working for you, quietly, eternally, lawfully. From that moment forward, every public office is bound to acknowledge it as evidence of standing, and every private entity must respect it as a matter of equity. The living record, sealed in good faith, becomes both shield and staff, protection and authority in one. Footnote: a sealed and registered judgment functions as a self-executing lawful bond, embodying both equity and enforceable value,